The rule regarding remoteness of damage in a contract was set out in Hadley versus Baxendale. In this case, the court held that a claimant may only recover losses which may reasonably be considered as arising naturally from the breach, or those which may reasonably be supposed to be in the contemplation of the parties at the time the contract was made. The facts of the case are: the crankshaft broke in the claimant's mill. He engaged the services of the defendant to deliver the crankshaft to the place where it was to be repaired and to subsequently return it after it had been repaired. Due to the neglect of the defendant, the crankshaft was returned 7 days late. The claimant was unable to use the mill during this time and claimed for loss of profit. The defendant argued that he was unaware that the mill would have to be closed during the delay and therefore the loss of profit was too remote. The court held that the damages available for breach of contract include: A. Those which may be fairly and reasonably considered arising naturally from the breach of contract. B. Such damages as may reasonably be supposed to have been in the contemplation of both the parties at the time the contract was made. If any special circumstances exist which were actually communicated to the defendant, the claimant may recover any damages which would ordinarily follow from the breach of contract under the special circumstances communicated. A similar question arose in the case of Victoria Laundry Limited versus Newman Industries Limited. In the said case, the defendants were to deliver a boiler for the plaintiff and the delivery was delayed by 5 months. As a result of not having enough laundry capacity, the plaintiff lost a high-value cleaning contract for the Ministry of Supply. The plaintiff sued for the loss of profits on the ground of: number 1, the large number of customers which could have been served if the said boiler was delivered on time. Number 2, the amount the plaintiff could have earned if it had received the contract from the Ministry of Supply. In the instant case, the defendants were aware that the plaintiff required the boiler for immediate use and therefore it was held that the defendant, as a reasonable man, could have foreseen some loss of profit, though not the loss of profit resulting from the special circumstance with respect to the Ministry of Supply's contract. Therefore, the defender was held liable to compensate for the ordinary loss of profits and not for the extraordinary loss. The House of Lords in England in Corfus versus C. Zarnikov Limited has enunciated the following principles. Number 1. In case of breach of contract, the agreed party is only entitled to recover such part of the loss actually resulting as was at the time of the contract reasonably foreseeable as liable to result from the breach. Number 2. What was at that time reasonably so foreseeable depends on the knowledge then possessed by the parties or at all events by the party who later commits the breach. Number 3. For this purpose, knowledge possessed is of 2 types. One imputed, the other actual. Everyone as a reasonable person is taken to know the ordinary course of things and consequently what loss is liable to result from a breach of contract in that ordinary course. But to this knowledge, which a contract breaker is assumed to possess, whether he actually possesses it or not, there may have to be added in a particular case knowledge which he actually possesses of the special circumstances outside the ordinary course of things, of such a kind that a breach in those special circumstances would be liable to cause more loss.